All right, what's up? What's up? Doug from Salt Lake. Okay, so we're in the middle of an administrative process right now. Monday, I will show you the paperwork. Monday is going to be my notice of default. So let's just go over the last couple of weeks real quickly, and let's see how the setup is coming together here. So the first thing we did, you'll see this was July 8th. Okay, this is a month ago. We sent a confirmation letter, and it basically says that I sent you all this stuff. Okay, I'll let you read it. Okay. June 13th, I got a letter, it says past due. So I said, but wait a minute, I sent you all this and you failed to respond. What happened? So I sent him a confirmation letter saying, hey man, you're in default. Okay, you have a duty to respond and you failed. And this is from me. And I sent 3 copies. Okay, I sent a copy to Alyssa, who's the agent, and Silverberg Williamson, who is the executive director of Health and Human Services, Office of Recovery Services, and Lisa Stockdale, who's the director. Okay, so all 3 of them have been notified. Okay, certified mail number. Okay, got the bottom of the page here, 1 of 1, got all your stuff in there. Okay, we got it on there. Okay, authorized representative. Okay, so there's the confirmation letter. They failed to respond. So what did we do next? So remember, July 8th was the confirmation letter, and I accepted your presentment for assessed value upon proof of claim. Okay? Copy is attached. So this is my letter of acceptance that I started. Okay? And you'll see that, once again, I'm using a notary now for this administrative process. Registered mail, so that I have one proof that they got it. That's the post office. Okay? And I've got a notary who's a, official, state official, an officer of the court, basically, that is mailing the document. Okay? So they can't come back and say, well, we never received it. Okay? It's going to them, July 24th. So 10 days has passed, and we're looking at our second mailing. Okay? And this is going to be August 5th. Notice of default, opportunity to cure. Okay? It's done by the notary. Certified mail this time, because once again, that's 1 witness and that's 2 witnesses. Okay? And this says you were sent a notice of acceptance. Okay? And here's the registered mail. 10 days to respond. Prove and provide a required contract for services. You fail to respond, you're in default, you're in dishonor. Okay? There's all the paperwork. You got 10 days from the date this notice is postmarked. Cure the breach. It would be your agreement to all statements made in the initial notice of acceptance. Okay, if you remember, the notice of acceptance says, if you don't prove your claim, you owe me 100 grand. And this is what we're looking for right here, a certificate of non-response. Okay, so again, on the 24th, the record shows that she mailed, okay, my notice of acceptance. The record shows on August 5th, she mailed the notice of default. Okay, verified by certificate of service. After both mailings, refused to validate the alleged debt, refused to provide proof of claim, nor did they send a notice of dishonor from a qualified third party, excusing their refusal. Okay, they did not cure their dishonor, and they gave no reason to confirm the adjustment and settlement of the account or send a notice of dishonor, and has not supplied a signed contract for services. Okay, that's what we're looking for right there. And once we get this, she signs it, she puts her little stamp on there, and then this is evidence in a court of law. And this should be the moneymaker right here. So let's go over this again. This is the United States District Court for the District of Utah. Okay, that's going to be the Superior Court or the federal court in the District of Utah, and we're going into a bill in equity. Okay? Because they're all commercial and it's all about the money, right? We know that. Jurisdiction and venue. Jurisdiction in this matter is hereby granted. Authorized representative for Douglas Richard Mooney, all caps, right? That's your ens legis. That's your transmitting utility. You are the authorized representative. You're the secured party. By way of sufficiency of pleadings, affidavit in support, I've showed you that. Amended complaint, bill in equity. Okay, here it is. Okay, the venue of this court is correct, as Douglas Richard Mooney does business in the state of Utah and is diverse from the United States, which means I'm not in the United States, doing business in the United States through my transmitting utility, right? And the amount in controversy exceeds $75,000. Who's the parties? Douglas Richard Mooney, all caps, has been domiciled in the state of Utah for over a year, right? That means I'm in this jurisdiction right here, right? Okay. And the Office of Recovery Services demonstrates a residency in the jurisdiction of the United States, yes, and does business in the state of Utah, yes, they do. Now, you know, some of those other guys out there will tell you that, you know, child support is federal. Some guys will tell you it's state. Some guys will say it's, you know, all opened up by the state and it's run by the feds. And you know what? Who fucking cares? Okay? That's not what we're arguing. Okay? You're in the state of Utah and you're doing business in the state of Utah. Therefore, you're inside the jurisdiction of Utah. Okay? Doesn't matter. The plaintiff, that's me. Well, that's not me. That's my all cap, has exhausted administrative remedy and comes to this court of equity with clean hands and in good faith. So what is good faith and clean hands? Those are legal terms. You should probably look them up, get a law dictionary and look that up. But this comes right out of the code in Georgia. And it says, in the ordinary course of business, when good faith, which means honesty and lawfulness, okay, requires an answer, it is the duty. What does duty mean? Liability, obligation, responsibility, okay, of the party receiving a letter from another to answer within a reasonable time. Otherwise, he is presumed to admit the propriety or the correctness of the acts mentioned in the letter of his correspondent and to adopt them, which means that you accept and you agree to the terms. If you don't, at least, you know, send me an FU letter. But that's what it says in the code, okay? And I highly recommend that you get a law dictionary and start looking up some of these rules, you know, these words, because I'll tell you, this is what I do whenever I'm, you know, like when I need a word, I need to know. Let's go to propriety here, right? So this is what I do, okay? And then I right click on it. And what I do is I go down here to synonyms, and it tells me the synonyms, or I just pop over the thesaurus, and it tells me other words, okay? And then I can look at a word, and I can say, you know, what the heck does that mean? Okay. Impropriety, decency, appropriateness, correctness, okay, politeness, good manners, okay, so that basically means the correctness of the acts mentioned in the letter. Okay, see how easy that is? Okay, so let's go back to the certificate of non-response and our wonderful bill in equity. This thing is amazing. It's nice and short, cuts right to the chase. So we know what our notice of acceptance is. We know what our notice of default and opportunity to cure is, and we have our certificate of non-response. Okay? And that's basically all you need. The plaintiff has already established a judgment in estoppel. Okay? So, what does estoppel mean? Let's look that up real quick. Let's right click. Let's go to synonyms. Let's go to the thesaurus. And of course, it doesn't say anything. Of course. Live on the air. Woohoo! Okay, but estoppel, basically the word stop is in there. You see that? So it basically means you are stopped from moving forward with your offer to contract, your consideration, your legal claims that I owe you, because you don't have a claim. You can't prove your claim. You don't have a contract. We're not in contract, and you are basically trying to produce jurisdiction and manufacture consent, and I busted you, and now there's nothing you can do because I've already got a judgment against you because you failed to respond. Okay? So plaintiff has established judgment in estoppel. It's already been estopped. It's already been judged against the defendant, as evidenced by the certificate of non-response, certified by the notary public for the state of Utah, County Salt Lake, right? Plaintiff's administrative remedy is res judicata. I think we went over that already. Okay? Res judicata means it's already been adjudicated. It's already been judged. Okay? And stare decisis means it's already been decided. Okay? And that there are no controversies and no facts in controversy, right? Plaintiff's administrative remedy is right for judicial review, and there are no facts in controversy. So you don't have to go in there and argue. There's no oral argument, nothing. Legal claims have already been adjudicated, okay? It's already been decided, okay? I am entitled to release in this equitable claim because they're trying to coerce money out of me, so it's all about equity, okay? I gave them a chance to prove their claim. I gave them a chance to validate their debt, and they did not. They failed to respond. Defendant is stopped for failure to respond to the original administrative process, and the plaintiff has placed the facts and law before this honorable court. Okay? There's no argument. It's already, I just want you to look and review my administrative process and remedy. Request this court find the facts and execute on the law of the contract before the court. Plaintiff requests summary judgment. That's all I'm asking for, summary judgment. And I request the court order the defendant to pay me $1 million for pain and suffering. Request the court to release the order of the court to Douglas Richard Mooney. Respectfully submitted, blah, blah, blah. Here's your notarization, okay? Received and sworn, did witness's signature on the foregoing, and here's your certificate of service, right? It's already filled out, it's ready to go. Real living soul, okay? Debtor's signature, and there's the authorized representative, sui juris, okay? In one's own, okay? So that's what we've been working on, and we are getting ready for my certificate of non-response. And there's something called latches, like a door latch. You might want to look that up too. That means that you have a specific amount of time to enforce your administrative process. And if you wait 10 years and then try to tell them, hey, well, I was gonna, but I didn't, it doesn't matter, okay? I've already got the money. I've already got the money put aside. And I'm going to take these people to court because I do not have a contract with child support. And I do not owe them $25,000. My son is 20 years old. He's doing fine. And he does not need to be coerced into a contract that I never signed and he never signed. And the mother just called ORS and said, he's not paying me. And yeah, I'm not even going to go into it. We've already been through it on my other 30 videos. Okay, you know what? It actually doesn't even matter if you're taking care of your kids or not. The state has an interest in your child because of a birth certificate, and you gave them an interest with that marriage license because you went to the state and you asked for their permission, and you gave them an interest in that child, and you gave them an interest in your corporation known as Mr. and Mrs. And you know, nobody knows that, and those are the facts. And you know, there's a lot of information out there. You got to watch about 10 hours worth of videos from Amen and Rickos, you know, Rick W. and these other guys that are out there. But you know, you don't need a birth certificate for your property, okay? But try walking out of that hospital without that baby, okay? And you'll get tackled by 6 nurses and 14, you know, security guys. You know, try getting married to somebody without getting a license from the state, okay? And see what happens. So it's all, you know, it's all so they can try to get jurisdiction over you, man. That's all it is. So this is going to be a quick one, just an update on what I'm doing. Tomorrow is the 5th, and that's going to be my notice of default, an opportunity to cure. I'm going to put out a couple of short videos tonight on some other stuff, so stay tuned. All right, take care.